1 year down and a lifetime to go. What I really learned in my first year of law school. Welcome to the No Spin Zone. Graphs Grievances starts right now. Having just completed my first year at Fordham Law School in New York City, I started reflecting on what I actually learned. Not just about legal doctrine, but about the American judicial system itself. And the truth is, this isn't about law school. It's about the much more unsettling reality of how our laws are interpreted by our courts. I'm not pretending to be an expert. I've taken 8 classes. But whether I was studying civil procedure, torts, criminal law, property, or constitutional law, one thing kept standing out to me. Judges have an extraordinary amount of discretion in deciding what the law actually means. Throughout American history, courts have created elaborate frameworks, balancing tests, standards of review, multi-factor analyses, all supposedly designed to help explain how judges reach decisions in a fair and principled way. But what really bothers me, and should probably bother you, is that virtually all of these tests are entirely judge-made. They were not passed by Congress. They were not voted on by the public. They are often not found anywhere in the text of the law itself. They are judicial inventions, frameworks created after the fact to justify an interpretation. That may sound obvious to lawyers, but to someone seeing it up close for the first time, it's striking. We are told judges apply the law, but in many cases, they are actively constructing the legal rules that determine the outcome. And once you start reading Supreme Court opinions, another thing becomes impossible to ignore. The methods the justices use to interpret the Constitution are completely inconsistent on both the left and the right. Take the Commerce Clause. Over time, more liberal justices have interpreted the word commerce so broadly that the Congress of the United States can regulate nearly anything under the theory that almost all activity affects interstate commerce in some indirect way. On the other side, conservatives often insist that the Constitution should be interpreted according to its original public meaning. But in practice, that originalism can feel highly selective. Take the Second Amendment. Whatever your politics are on guns, it is difficult to argue that the framers had modern firearms in mind when they wrote that amendment. They lived in a world of muskets. Semi-automatic weapons were not just uncommon, they were unimaginable because they weren't invented. So when people claim that history provides one clear answer, that's hard to take seriously. Because the deeper truth is this: it is often impossible to know exactly what the founders intended. The framers disagreed with each other. They compromised. They used broad language on purpose. And many constitutional provisions are written at such a high level of abstraction that multiple interpretations are entirely plausible. The Constitution is both foundational and deeply vague. That means that many of the most important legal disputes in this country are not resolved by uncovering some obvious original answer. They are resolved by judges choosing among competing interpretations and then writing persuasive opinions to justify the outcome. And if you read enough opinions, you begin to suspect something very uncomfortable. The reasoning often comes after the conclusion. You heard that right. The justices decide where they want to land and then build the analytical bridge afterward. That may sound cynical, but recent events make it hard to dismiss. Take the Supreme Court's increasing use of the shadow docket. It has exploded under Trump's second term. The shadow docket refers to emergency orders and decisions issued without full briefings, without oral arguments, and often without detailed written explanations. In other words, the court increasingly decides enormously consequential issues without even maintaining the formal process that is supposed to legitimize its decisions. No lengthy opinions, no transparent reasoning, no questioning of lawyers, just orders. That should concern everyone regardless of ideology, because if courts are going to exercise this much power over public life, the least they can do is explain themselves. And that brings me to the Constitution itself. The more I studied constitutional law this past year, the more I came to believe something that would have surprised me before law school. The Constitution, as written, is far less capable of protecting modern rights than most Americans assume. The document was drafted by 18th century political elites trying to solve the problem of 18th century political elites. It tolerated slavery, it excluded women from political participation, and it preserved systems of hierarchy that are fundamentally incompatible with modern American values. Of course, the Constitution has been amended. The Reconstruction Amendments transformed the country after the American Civil War. Later amendments expanded voting rights and democratic participation. But here's the structural problem. Amending the Constitution is extraordinarily difficult. In fact, the last successful amendment, the 27th Amendment to the U.S. Constitution, was ratified more than 3 decades ago. So while society changes rapidly, constitutional text changes very rarely. That creates a gap. On one side, we have a constitutional document that is fixed, old, and nearly impossible to revise. On the other, we have evolving understandings of liberty, equity, privacy, and civil rights. So how do we bridge that gap? In practice, mostly through the Supreme Court, and more specifically, through justices willing to interpret the Constitution as a living document rather than a frozen historical artifact. Historically, many of the most significant expansions of individual rights come from justices appointed by Democratic presidents or from coalitions that included them. Those justices were often more willing to interpret broad constitutional language to extend protections to groups that had long been excluded from full equality under the law. That means the expansion of rights in America has often depended not on constitutional amendment, not on Congress, and not directly on voters, but on unelected judges. That is an extraordinary amount of power to place in the hands of 9 unelected people wearing robes. And it becomes even more concerning when the court shifts ideologically. Today, the Supreme Court consists of 6 justices appointed by Republican presidents and 3 appointed by Democratic presidents, including 3 appointments made by President Donald Trump. That matters because if constitutional rights depend largely on judicial interpretation, then changes in the political makeup of the court can determine whether rights expand, stagnate, or even disappear. The Constitution has served as the foundation for some of the greatest expansions of liberty in American history. But in many of those cases, that happened only because judges interpreted broad constitutional language to protect rights that are not explicitly spelled out in the text. Cases like Brown v. Board of Education, Loving v. Virginia, Obergefell v. Hodges did not emerge from constitutional certainty. They emerged because judges read old words in light of new moral realities, which means our rights depend not only on what the Constitution says, but on who happens to be interpreting them. That is not only a fragile system, but a bad system. And in a moment when the court is more conservative than it has been in generations, that fragility is impossible to ignore. If the protection of minority rights depends on a favorable majority of justices, then those rights are not secure. This is why I believe constitutional reform is more important now than ever before. Because a free society should not require citizens to hope that 9 unelected lawyers who wear robes will continue to recognize rights that should already be clearly guaranteed by the law. So what did I learn in my first year of law school? I learned that law is not nearly as objective as most people think. I learned that courts are not merely neutral referees calling balls and strikes. And I learned that much of what we call constitutional law is really an ongoing political struggle over who gets to define freedom, equality, and justice in each generation. That realization is deeply unsettling, because if our rights can be protected by judges creatively interpreting a centuries-old document, then those rights are far less secure than we pretend. And maybe the problem is not just the judges. Maybe the problem is that we have convinced ourselves that a document written in 1787 can govern a society the framers could have never imagined. Thank you for watching Graf's Grievances. Let me know what you think. Please like, subscribe, share, and join me next time.